Thanks, everybody. We appreciate you joining us for this session. Really, it's all about you have the case, you have your docket. Now, what do you do, right? Cases are retained. What next? And joining me on the panel, we have some amazing experts. I'm going to go down the line, let everybody introduce themselves. We'll start with Damon. Damon, tell everybody who you are and why you're on this panel.
Hi, everyone. My name is Damon Spiceland. I'm the Chief Revenue Officer with MedChart. I'm on the panel because we've been working on the Purdue project for over a year now, and we have literally about half the docket that we're working through, so we have become the experts. Great. And then we'll keep going down the line. David, you're next on the block. Tell everybody a little bit about you and why you're here on the panel.
Sure, thank you. David Yenna, I'm the president of Fairmax Bankruptcy Consulting, and our role in these type of mass tort litigations is to provide comprehensive bankruptcy support for any of the claimants that do file bankruptcy, no matter what chapter that is.
Excellent. And now we go to Darren. Darren, same question.
Excellent. Thanks for having me on. I'm Darren Finling, the founder of the Probate Pro. We're a multi-state law firm providing probate-related support to the mass tort industry. I'm on this panel because, not surprisingly, people die during mass tort matters, and we are the solution for probate payment complications. So giving the plaintiff's counsel standing to address their related issues during their litigation through the probate system nationally.
Awesome. Next up, Ed Gentle, who probably needs no introduction, right? You're famous for being expert on these panels. So Ed, tell us a little bit about you.
I think I'm the elder on the Zoom. I've been practicing law 40 years. I specialize in being a special master in mass cases, especially MDLs, also in mediating settlements of mass cases and creating the settlements and administering them.
Awesome. And then following up with Ed, we have Hunter Linville. Hunter, thank you for joining us today. Again, you probably don't need much of an introduction. You're one of our more famous panelists.
Oh, yeah.
Yes.
Happy to join. Hunter Linville. I am a mass tort plaintiff's attorney and specialize in handling medical devices, pharmaceutical cases, work on plaintiff's leadership, and my firm does marketing for these types of litigations, and we handle the cases, taking them through filing the lawsuit all the way through settlement. So work with a lot of these guys all along the way.
Excellent. And then last but not least, Ryan Weiner. Tell everyone hello and a little bit about what you do.
Thanks, Randy. Ryan Weiner from Massive. I'm the Chief Operating Officer. We are as simply put, a lien resolution company. We do much more than that, but in this conversation, we are talking about resolving all of the Medicare, Medicaid, ERISA claims, any kind of health insurance liens that are going to be required and necessary to finish out a case right before disbursement.
Excellent. Okay. And I think the reason why we have the panel is I know there's a lot of emphasis that's put on generating the case. And we see that a lot during the business tracks of different conferences, especially during Mass Torts Made Perfect. And I feel like there's not a lot of attention placed on what happens next. And I think maybe we'll start with Ed, you, if you wouldn't mind, because I know you have a breadth of experience in these matters. Are there things that we need to be concerned about, whether you're referring it to a litigation attorney like Hunter, or whether you are that actual litigation attorney? What are the things that we need to really keep our eye on? What are the things we need to worry about?
Yeah, I think there's a couple things that we see perhaps not done perfectly. First of all, before jumping into a mass case, you should do some due diligence. I'm administering a couple what I would call MDL workouts. I'm not going to name them, but it turns out that these cases were jelly side down. One was jelly side down because of FDA preemption. One was jelly side down because all the Daubert experts were tossed. And so before you get into a case, I would do some due diligence to make sure you reasonably believe it'll fly. The second thing I would look at is at the beginning, and this helps the other people on this Zoom, to figure out what the ABCs of the evidence are. Right now, early vetting and culling is a big theme of the defendant. So you might as well get your act together at the beginning and have real cases and non-cullable cases. That's happened a lot in Benacar, for example. And so that's something to be worried about and at the front to make sure, it's garbage in or garbage out or good in and good out. So have good data, make sure you can prove each case. And then the other thing I would look at is you decide whether the case can settle before the plaintiff lawyers run out of money. And we have third-party lenders, which I see a lot of, unfortunately, is to figure out if the cases have what I would call fulcrum issues, where you can leverage the defendant into settlement, because that's always the goal. And some examples are to look at is issues, an issue class. That's becoming more and more popular. Figure out what fulcrum issue, if decided, would really have the defendant in a vulnerable position. For example, if you have contaminated blood, was the defendant negligent? Or a product that was produced with a certain issue, did the defendant did the composition wrong? Something like that. And then finally, as you do the ABCs, be sure you can spread the cases based upon their relative values, because bellwethering is very popular up front. And so you need to figure out the diamonds and the coal early on.
I think that makes sense. And I want to come to you, Hunter, in a moment, but I'm just going to ask Damon first a question. In my rudimentary sort of process, I feel like, okay, prove up maybe is the first thing that we talk about, right? We have the case, and now we have to see if we have our proof of use, proof of injury. And so prove up, we look at Damon, and Damon, you're leveraging technology right now, and you're leveraging data in a way that appears to be pretty innovative. So maybe you can talk about that, especially when you mentioned at the beginning the Purdue litigation, right? Take us through some of what you're seeing, and what are some of the ways that people can stay ahead of the game and make sure that they're protecting their docket, if that makes sense.
Sure, and thank you, Randy. Ed brought up a really good point about data and clean data. The biggest thing in data is input, throughput, and output. And with bad data on the input, it skews the whole process. What we have specialized in is bringing in a lot of artificial intelligence, but most importantly, we spent the last 3 years building healthcare relationships to bring in unique access specifically to PBMs or pharmacy benefit manager platforms. So able to go back and find records that typically are unobtainable. With a lot of the docket going back such a far historical reach, it is a challenge to the firms and to traditional record services to find these records and golden nuggets. So we've been able to really streamline these processes, automate the ability to go out and capture this data that is able to qualify these individuals and claimants. So that's been one of the biggest strong suits. And on top of that, really it's been working with the law firms, helping them to aggregate the data and then put it into an automated platform. We're able just to streamline how we work with them, how we process the records, and how we get the records back to their hands. So everything at the end of the day is just enriched by data and AI technologies.
And I think what's interesting from my perspective is, and Hunter, I'm going to come to you about this, but the process, let's say you're starting the prove up process and maybe you're touching it first, but there's information that you're going to need to share with everyone down the line, because obviously the people that are worried about bankruptcy issues, the people that are worried about probate issues, and then of course, ultimately the people that are going to be resolving all the potential liens, you guys all have to sort of work together and share data. And I'm surprised how little that it seems like it happens, but I know you're trying to change that. And so is everyone on the panel, which I think is real important. So Hunter, just jumping over to you, you're widely considered one of the best processes guys by the people that I've spoken with over the last, few years. What is it that you see that are the biggest mistakes, if that's fair to put you on the spot, that people are making, and what are things they need to pay attention to, starting with prove up, going all the way through the process to resolution?
I think I think the focus on being able to share the data with multiple parties as it moves down the line is important. And to do that, the work starts up front. As soon as you get the case, you've got to think about how you're going to standardize your data. What are your key data points that you need to look at immediately, and how will you get those to different parties? So if you're going to work with someone like Damon, which I have on getting records, he has a different system than Ed has, right? But if I'm looking ahead and I say, all right, even when I'm doing my intake and I want to have Damon help me get records, I want to give him this data. It needs to be in my system so that it's standardized in a way I can get it there. And then when it gets time later on, I can go to Ed and give him the information. And I don't have to go back each time and have to go back and pull that data out of the records or go and download the files and have someone in my office review it. I think a lot of firms spend a lot of time redoing work like that because they don't have it standardized up front. So I'd say that's probably the biggest issue I see.
Okay, and then I'm going to come flying over to you, David. I think one of the meetings I was in when we were talking about moving through settlement, I remember the issue of bankruptcies came up, and I didn't realize just how complicated that stuff can be. And I feel like much with probate, I feel like everyone waits till the last minute and then they have a monster on their hands. And David, tell me if that's right, if I'm dreaming, or give me an idea of why you're so vital and why you should get involved early.
It's a monster if it's not done right, because if you're making disbursements outside of a bankruptcy, the consequences can be severe. Once a individual files for bankruptcy, they no longer hold the rights to that claim. They know that belongs to the trustee, and it belongs to what's called the bankruptcy estate. And now it's up to the court to approve employment of plaintiff counsel, approve any settlement independent of the actual litigation. All of that needs to be vetted through the bankruptcy process. And if it's not done so, and then later discovered there was a bankruptcy, that all has to be peeled back. A case has to be reopened. Fees may have to be returned. It can create a big, big mess. So it is important to actually monitor, the claimant's files throughout the process, have some sort of system which we provide to discover when actual claimants file bankruptcy, but also when it's time for a settlement, to also vet and scrub all of those claimant files to make sure there isn't a pending or previous bankruptcy that needs to be addressed before any funds are dispersed. So it's very, very vital that is done in order to avoid a big mess.
Right. And if you look at a docket, let's say you have a docket of 100,000 claimants, or not even a docket, but let's just say there's 100,000 claimants within like a litigation. Do you have to check everyone? Is there a process? Is that really what it comes down to?
It's our recommendation that you scrub every single claimant. No matter how large or small the settlement, each person who files bankruptcy has a duty to disclose this claim. There's a duty to, you want to be proactive as plaintiff counsel to make sure that the trustee in the bankruptcy case is notified of this claim, independent of even the actual claimant themselves notifying anyone of it. Yes, the strong best practice is to scrub each and every file and make sure that you're doing your due diligence properly and notifying the appropriate parties.
Right. And then, of course, let's talk about probate. So what's really funny is Darren always says, well, people die. And they do, right? So tell us, same sort of process. Maybe people aren't aware that someone's died in the middle of a litigation, right? Or maybe, is it on behalf of filings? Like, talk to us a little bit about the complicated world you live in and what people need to be aware of.
Absolutely. And because probate is state specific and often county specific within each state, there's no one answer to this, but there are some really important lessons. And that is, most of the mass tort industry would wait until the money was on the table before they even thought of probate. There was a case some years ago called In re Engel, which really shocked the mass tort world. In Florida, 588 plaintiffs' cases were dismissed because they had failed to open up probate estates and they'd blown the statute of limitations. And it caused the mass tort industry to look at this particular issue much earlier in the process. So we urge people to look at their plaintiffs, if they have died, get an estate open, because in many states, you don't have standing to bring forth the claims without a personal representative, a letter of administration in place. So we encourage you to do that at the onset, not when there's money on the table. Our particular office provides a national solution to this problem. So we're like the one-stop shop. So most of the mass tort industry that works with us essentially hands us their entire list. And on any given year, about 1% of the population dies. So within a mass tort context, you have to assume at least 1 to 5%, depending on the tort, is going to die at some point. And it would be probate that should be on people's radar to avoid the risk of missing a statute of limitations by having the appropriate plaintiff in place.
Interesting. And I know coming over to you, Ryan, you sort of get it early and late, right? So Ryan, your world is subrogation. So you start to see things early, depending on how quickly you get involved in a case or in a file. All this sort of works in concert, I'm guessing. So help us understand why it's important to also get you involved early, if you could.
Sure, no problem. Before I even get into that, one of the things I like to mention too is all these things can happen simultaneously. You don't need to talk to each one of us individually. We can be working together or separately, but still at the same time. So where we run into issues early in the process is generally, I think there's a little bit of a superstition about starting early when it comes to lien resolution. There's nothing wrong with at least investigating and setting up your files and making sure that you know what your universe looks like. You know, if it's a hip replacement, generally it's going to be an older universe. You know you have Medicare to deal with. Start figuring out who's handling all the Medicare claims. Obviously, we have CMS for regular Medicare, but then there's, I think, 35 million, if I'm getting the number right, Medicare Advantage individuals in the United States right now. You have to look for those kinds of things and say, who's handling all the Medicare Advantage? With that, then you can start focusing on, here's who I want to deal with as my main lien resolution programs. But then you also remember there's other lien resolution programs that might have 10 or 12 different insurance companies. That's it. There's so much out there. You just need to keep it really well organized. And that's where doing everything simultaneously might actually help us all. One of the big things that we've run into in the past is the attorneys were going to say, well, we don't have probate ready yet. And while Darren just explained why that's a mistake, it may not matter if you talk us through it too. We can do a qualified protective order and we don't have to worry about probate for our purposes in lien resolution. So have to worry about it for the rest of the case, but we don't have to sit waiting for an authorization signed by the next of kin who may or may not be authorized yet. These are all things you have to think through initially. And maybe it is that you don't want us to start early. Maybe you're superstitious. You don't want to step on the foul lines going onto the field, but you can still get it all organized and be ready and say, we have our plan ready to go. And as soon as you get that letter of understanding or a memorandum of understanding, if you want to wait for the master settlement agreement, wrong MSA about to mention, if you want to wait for the master settlement agreement, you can, but you have that plan in place. You can start running it immediately. And then don't worry about whether or not it's going to be 6,000 claimants or it's going to cool down to 4,500. Let someone like us start our work. We don't care if we're going to lose some of them because ultimately it's going to speed us up by 3, 4, 5 months. You can disperse when the clients are calling as opposed to 6 months after they start calling.
Right. Okay. So then back over to you, Hunter, and then I'll come to you, Ed. The idea is that all of this is a lot to sort of keep organized. I'm sure, Hunter, your firm does an exceptional job at doing that. But do you agree with what everybody's saying? It's important to get all these parts sort of moving, and is there anything that you disagree with? Just not, again, I keep putting you on the spot because it's fun, but give me an idea from your perspective, because you're the guy that actually is either given the cases or gets the cases yourself. So this is practical knowledge that you can share with everybody watching.
No, I agree. I agree. It's good to start early. I think some people don't want to start it early because a lot of these services do come with a cost associated to them for each claimant that you take to them. You know, whether it's probate services or bankruptcy, whatever. But the cost alone shouldn't be enough to keep us away. I mean, I think in a way it should help force us make the really hard decisions to cut some of these cases earlier on, to do a very good job up front of screening the cases, making decisions on the marginal cases that might not fit the criteria that the litigation is really looking for. I think there's a tendency to hold on to cases for way too long. And I think Ed mentioned this earlier. Then when you get into settlement and you have someone like Ed trying to help you put your settlement together, you've got your cases that they meet the criteria and they're pretty solid. And then you've got a bunch of cases that you got to find something to do with because someone has filed a bunch of cases that had a very, very, very small injury, or it's not related to maybe the product as much as the other ones are because of maybe the date of use and the injury, maybe they're further apart. But I think there's a tendency to try to hold on to those cases and hope that they'll get paid. But it does create a lot of problems in the end for everyone else that has actually reviewed their cases and tried to keep their docket pretty clean. So I think getting people involved early on, obviously it speeds things up. And in the end, when you know your clients are waiting for their money, you talk about death cases. Well, I know we've probably all seen this before, where you're in the settlement and you're waiting on lien resolution or something like that, and then your client dies at that point, and now you've got to open up, maybe another probate because it's taken so long. So getting that lien resolution out of the way up front, getting that process started is very helpful because you want to be able to distribute this money as soon as possible.
I think that makes sense. Ed, I sort of imagine that everybody just comes in with a big wheelbarrow full of issues and dumps them on your desk when you're doing claims administration. So maybe I'm wrong there.
Well, ironically, what's happening in two big cases I'm administering right now is the defendant agreed to split the overhead in working them up. And so I would not eliminate that possibility. And the way it works a lot of times, my popular method to settle a mass case is what I call the grading workshop. So what we do is we say, okay, plaintiffs, give me your 10 best, and defendants, give me the 10 worst, and I'm going to pick 10. And then we get together in a room. I guess we do it virtually now. And we have a simple scale of 1 to 10 and see if we can agree on a scale. And Stockholm syndrome tends to set in, and as you proceed through that process, you try to get the plaintiffs and the defendants on the same planet first, and then try to resolve the case. But as you work the case up, you really have to get granular for this reason. You can't figure out what it takes to settle a mass case unless you do an inventory. There's no way around it. Otherwise, you're just shooting in the dark. So many cases have settled in which I have a bucket of money and too many claimants. And the way to avoid that is to do a granular analysis. And what we do as far as probate and bankruptcy and liens is interrelated with that. And as you size up your inventory, you should do that background work too. And there's a hit manufacturer that's agreed to split all that overhead. I'm not going to name them. And there's a drug manufacturer that's agreed to split all that because they want to know also. And a lot of this information we've talked about in a real sense is neutral information. It's some information that the plaintiff lawyers in many cases are comfortable in sharing if the cost is split. But what it does, it allows you to measure your inventory and what it's really worth and what it's going to take to get the money to the mailbox. So I think that's the approach I would try to take in a mass case.
Yeah, I think it's interesting. They do that in Canada. Everybody sort of just, it's sort of, I guess I liken it to the idea of behind the census plus, right? The idea is that, you have a shared expense because the information is needed for both sides, right? You have to look and see what you're really dealing with. It gives you a better understanding of the universe, maybe. But again, it's, I think there's lots of pitfalls throughout the entire process. So, we're going to keep trying to evolve as we go. Let me jump back over to you, David. One of the things I think I'd like to try to highlight is maybe some of the things that go wrong while you waited, right? So it's going to sound a little bit odd, but if you don't get involved early, what are some of the things you've seen that you've had to deal with because people waited too long to get you involved?
Well, just it's more delay and cost. If you have bankruptcies that are going by without notice, and without the claimants actually disclosing this potential asset in their bankruptcies, and they close, you actually have to then go back, notify the appropriate parties, have those bankruptcies reopen before you can do anything. And particularly if fees have already been dispersed, that's a problem, because that should have been done through the bankruptcy process. And worst case scenario, you can have trustees who actually seek return of disbursements and seek attorney fees to be returned, seek the debtors or the claimants to actually return their settlement proceeds so they can be administered through the process. So you want to catch all those things very early on. There are some cases, it's rare, where there's even a judicial estoppel claim made, that if you put on your bankruptcy petition that you didn't have this claim, you basically waived your right to make it, and you actually lose your right to the claim. That's not something that happens so often. More, it's about curing and reopening the case, but all this comes with a cost, delay, reopening a case, getting all the appropriate motions by the trustee, and you just hope that there weren't any disbursements before any of that happens. So to spot all these things early on, make sure that the claimants are actually disclosing the claims in the bankruptcy as they go, so that the appropriate motions and everything can be filed, and plaintiff counsel can be actually hired a special counsel by the bankruptcy trustee. Just make sure that the process is streamlined, and when it's time to settle and disperse funds, it can be done smoothly and efficiently.
Okay.
So that process is very important to be done from the beginning.
Sure. And Damon, I'm coming over to you. Interesting, because I know you get involved early, so that's helpful. But at the same time, there's been a delay with certain dockets where you were sort of brought in and say, hey, quick, prove all this stuff up. We've got a filing date or a deadline. Talk to me about how important it is to get you involved early, because if you don't get to prove up the case, then there is no case, right? I mean, I'm not answering the question for you, although I guess I just did. But yeah, so tell me a little bit about why it's important to get you involved early.
Sure, thanks, Randy. It's been very unique working with the different law firms who are involved in this current project based off of the stage of where they currently are and their goals to get there. For us, it's so important to get involved on that particular point, because we're working with the law firm to get that information together. And by working together, utilizing the technologies, we're able to reduce the time frames, typically 6 to 9 months, down to 30 to 60 days to get everything organized. So by getting ahead of the curve, we're able to get working on the project. And then by utilizing our technologies, we're running through tens of millions of pages that usually take these service companies years to go through and qualify the work. And as we go through each page, we keep educating our AI, and we keep getting smarter and smarter and smarter. Also expanding criteria. There's NDC codes for these drugs that are redacted. Even Purdue doesn't know what these numbers are, and they're not released. So we're actually expanding the qualification criteria. So the sooner we get involved, the more work, overhead costs with law firms are reduced. The quicker you get your claimants qualified, the quicker they go to the next step, and the quicker that money gets to their mailbox. So overall, it's a win-win. The quicker you can get working on this project together.
Yeah, and it's interesting you say, expanding the criteria. Well, that's a big point, right? Because the idea is, if you're able to get involved and actually help the law firm uncover more potential compensable cases, that makes you a pretty popular guy in the room, right? So talk to me, if you can, a little bit, help people understand watching this, what that really means for them. Give us an example. And then after you do that, give me an idea of how. I'll save that question until you answer that. You answer that and I'll give you the next question.
Okay. So there's 12 brand name drugs that everybody is looking at. There's been a lot of confusion with a lot of the smaller firms based off of what's online with the Purdue settlement and the Percocets and Tramadols and how that would qualify. So we've taken the initial qualification criteria and then understanding the patents that carry over. For example, OxyContin is an extended release oxycodone, but that's a brand name drug of Purdue. So if you're looking at where Purdue owned the patents on these extended release variations, they own the patents on like 90% plus of a lot of these extended variations. So as we go through and you look at extended release, then you uncover that there's 10 different, abbreviations for extended release. SA, CER, XER, XR, it just keeps going and going and going. So as we're going through records that are going back 30 years plus, we're uncovering these NDCs or national drug codes, and we're able to identify these. And it's real important because when you're looking through the records, you may get drug codes on one, labelers on another, but you very rarely get the whole picture depending on the record provider, hospital, pharmacy you're getting the records from. So we just keep digging further. And every day when we uncover a new qualified criteria, we verify it, we vet it, we share it, and then we build that into the AI. So we're able to get to new unprecedented levels of qualifications. And a lot of the firms were ecstatic if they could reach 50%. We've seen as high as 70% of the dockets qualified. And that's before we go into what we call phase 2 or deep dives. We can go as far and deep as you want to go, but we're in tune with the law firm and the claimants to make sure we follow that line of diminishing returns, and we're conscious of every dollar spent. We even are huge advocates for provider fees. We know the profit centers the hospitals are, so we have an entire team dedicated to reducing those provider fees, which we've seen up to 50% reduction in most cases. So it's all critical, but at the end of the day, we dig and dig and dig and dig to qualify everybody because we're attached to these stories, these claimants. I have one individual from the first month we started on this. It is my mission, my goal, my passion to qualify this individual. So I have spent tens and tens of thousands of dollars for this one individual that's out of my pocket because I'm so close to this project.
Wow, that's pretty good. I don't know if that's a scalable business model, but yeah, that seems like that's pretty good.
just the one, but it's something we're passionate and we're connected. And as we read these and we hand review every document, every page after the AI, OCR, and ICR runs through. So at the end of the day, we're connected to these patients on a very personal level.
No, I think that's good. And it's probably good for all the attorneys out there to hear that, all the people that you trust to help you with your case, they actually care about your claimant, right? So I'm zipping over to, I'll come back for the question I was going to ask you, but I want to go to Ryan next. So Ryan, it feels like to me, in the beginning of a case, you want to find everything you can and make it relate to the injury, right? So the idea is that everything is related. We can show you with all of this medical information, all of this is related. Then when you have to resolve the potential liens, your job becomes none of this is related. And so give me an idea of how that works, because you have to tell everyone how no, the only thing that's related is the chipped thumbnail.
Right. And the thumbnail was not chipped in this case. Let's not do that.
Yeah.
So the important thing to us is to think more like the defense. And I know that sounds a little bit dirty in this conversation, but I love to see the defense's arguments after they have not successfully worked and after you plaintiffs have successfully used your own arguments. The defense arguments are what I can use to say, well, wait a second. Yeah, the plaintiff said everything under the sun was related, but that's not true. That's never true. So this case is done. Everything is settled. Let's find the same middle ground that plaintiff and defense found. And oftentimes it means I actually look at what the defense has used. In a single event case, it's easier to say, Dr. So-and-so said that Ryan was not injured in this accident. But in a mass tort case, obviously, we may not have the same kind of direct statements like that. It doesn't matter. We can still use that information. Whatever we can get is helpful to us. If I hear Damon's team is involved in the case, I'm ecstatic. It means I have so much more data to look at. I can say, well, gee, yeah, sure, this guy was using Purdue, but they were also using opioids from Mallinckrodt. And I can't think of any others right now, but it doesn't matter. The point is, if I have all that data, I can make different arguments. And that's really important to me. And I promise I will never talk about using defense arguments except after the case is settled. But they're really what we need.
And it's funny, your process is pretty unique because like Damon, you use technology in a way that I think is quite interesting. Tell everybody a little bit about that so that they can understand better how you even arrive at where you start tell us about your process.
I can do that. So while spreadsheets are helpful to get us started, in the end, you know that you're going to be getting too much data to just look at a spreadsheet. And because of that, we've built OCR technology, we've built AI into it. And we take all the information we get and we can just run it through systems so that the human eye can't make any mistakes, can't say, oh, well, I'm not so sure about this. Computers can tell us what was paid for by Medicare. They can tell us what each one of those things looks like, and we can scale everything down to something where the human eye can now look at it and make life a little bit easier. That speeds the whole process up. And in the end, you need to have that kind of data resource. There's, on the other side of that, there's still companies that are using paper. Thankfully, Medicare is not when we're doing mass tort cases. But if you have 50,000 plaintiffs, there's going to be 10,000 individual liens. You need to have the processing power to get through those. It's as simple as a regular OCR that says, okay, we know this letter is from Humana, we know it's for Randy's injury, and we know that they're claiming $75. But that kind of technology is paramount to making things move fast. You can't process that many letters as a human being. So hopefully you can get together with all the other companies you're working with and make sure that technology connects. We can also get ahead of the game by talking to companies like MedChart and saying, show us the data that exists already. Of all the 10,000 plaintiffs in this case, can we see how many had Medicare, how many had Medicaid, how many had this and that? And that lets us focus in on the organizations where we want to do global programs, and then wait. I'm not saying ignore, but wait to look at the ones where maybe it's Hawaii Medicaid and there's 3 plaintiffs. You're not going to do a global program there, but you at least know you don't have to talk to Hawaii yet. You may want to fly there later, get in the sun a little bit, but it's not on top of your head right now.
Yeah. Make it harder for them to outsource that to you, I'm guessing, the Hawaii and deal with the health.
That should always be outsourced to us because I'm flying there.
That makes sense. All right, Hunter, I'm coming over to you because we're talking a lot about very specific parts of the process, but in order to really do this panel justice, hey, pardon the pun, the idea is the case has been retained. Now what? So other than bankruptcy, probate, prove up, and of course, resolution or subrogation issues, there's probably a lot of stuff that the lawyers need to do, right? So talk to me about the process from retention to resolution that is important, that people should be paying attention to, and what you do at your firm to have such a good reputation for being the processes guy.
Well, I think to start with, you've got to do risk assessment on the litigation, whether or not you should be marketing for the cases or be involved in the litigation at all. And that goes back to, I think, what Ed was talking about earlier, looking at the different issues in the case, getting to know the case to see if it's going to be a long litigation, if it's going to require a lot of litigation, or if it's something that's likely to settle soon. You can't always predict that, but being able to do a risk assessment around those things is important to try to understand whether or not you think it's the right one for you. Because if it's going to require litigation, if you're going to have to do depositions, if you're going to have to possibly go to trial in some of these cases, you need to know that that is a possibility and that you can handle it. And that goes for the.
Oh, we may have lost him for a moment. He probably had bad weather in Atlanta. Ed, I'm going to let you pick up where he left off because you're the closest one to being able to carry that tour. Oh, Hunter's back. There you go.
Go ahead, Hunter.
Yep, go ahead, Hunter.
Sorry, I don't know where I cut off, but I was talking about the risk assessment, and the other thing is looking at the cases, knowing what you have. You've got to standardize the data so that you can look at your cases and try to identify which cases are good and which cases you probably should let go so that you're not continuing to put money into those cases. And the main thing is you want to be able to give your attention to the really strong cases that you have, so you keep those clients engaged. That's one of the big things. I think we all are familiar with dual representation, where one of your clients probably has an attorney somewhere else, maybe 2 or 3 other attorneys working on the same case. So, having constant contact with your clients when you first bring them into your firm, setting up the communication, letting them know what numbers you want them to call, where they can get the best responses from your team, introducing them to the people on your team that are going to be handling their case, and just continuing to reach out, give them updates so that they know you are their attorney. They don't need to respond to any other ads they see and go and find another attorney. But I think that's one of the biggest things that would go a long way in, I guess, cutting down on some of the dual rep issues, and just not seeing your docket completely fall off with lots of your clients going missing, or just starting to lose interest in the litigation. I think sometimes they might even forget they have a case with you if you are not reaching out. So I think there's got to be more outreach. So you've got to make sure you have staff and the communication tools to be able to reach out to your clients consistently. And you can set up alerts within your database so that each client is getting a letter every 60 or 90 days, whatever you come up with. But being able to set those alerts in your database so that you can see it from an overall perspective. You don't have to worry about, well, I need somebody to go into each file to make sure this client's been called or they haven't been called. That's not scalable, and you can't stay on top of the deadlines you have like that. So, one of the biggest things we do when we first get the case is we're going to go in and we're going to confirm the contact information. We're going to confirm the facts to make sure that the facts that we got during the initial screening, we're going to do a more in-depth analysis there and try to confirm all that information. Confirm healthcare providers, confirm that they actually had the injury that they first reported, and then we're going to start requesting records very early, because as Damon was talking about earlier, if you wait too long for that process, you're going to miss out on getting records, because some facilities they have certain time period that they will save the records, and you getting your request out one month versus another may be the difference in getting that record or not, because it may get it may go away. So I think getting that part set up very early, getting moving on getting your records, know your docket, know what the cases look like, and starting to focus on building the data around that, so that as you move through the process, as you move through the different stages of litigation, you can start sharing that information with the parties that you need to, all the way through lien resolution.
Yeah, I think that makes sense. Ed, since I was going to let you finish his thought when he popped off for a second, can you add to that? Because you must see a lot of avoidable.
Yeah. I think really let's talk about the political aspects of this. Practicing law really takes some sharp elbows. It's a contact sport. If you read all the reported cases, they're really about lawyers trying to box each other out, like Fred Barron killed Kim and so on. That's just how it works. And so if you're going to represent your clients wisely, you've got to wiggle in there. When you figure out what judge has the MDL, you might try to size him or her up and try to get in leadership to give your client some oxygen. Because a lot of times what happens in mass cases is a lot of lawyers and their clients get disenfranchised. By that, I mean they don't have a voice in what happens. They don't know exactly what's going on. And the clients get upset because they don't hear anything. And so it's very important to form alliances with other plaintiff lawyers, to be involved and really to fight for your client to get a fair return. A good example is the GE ignition switch case. The guy that thought of the case got boxed out of leadership, and they rearranged who's going to be tried when, and he ended up suing the PSC. So you really have to think about that. The technology is great. We have a lot of experts on this call, but in the end, a lot of it is somewhat brawling, and you just got to be willing to do that and fight literally for your client.
Yeah, I think that makes sense. And I think, to all the people on the panel, I think if you've got more people in your corner, the fight goes a little bit more easy, I say, right?
Yeah.
There's got to be, yeah. So, all right, so we've probably got about 5 minutes before we go into questions from the audience. So maybe what we do is I'll just go around and everyone just, if you have any final thoughts you'd like to share, and what we'll do is we'll go to Darren, who's been sitting quietly. We'll start with you, Darren. No pressure, but any final thoughts you'd like to share with the people that are watching?
Yeah, I think everyone who is listening understands that death is always going to be a part of their cases. And with death means that you have two choices as a mass tort plaintiff's counsel. One is ignore it and then suffer potential consequences from ignoring it. And the other is to lean into it and take it on. We also know that nationally, there are many, many counties, many states, and probate related issues vary state by state, county by county. And it used to be, the old model was that you'd find a probate practitioner in each place all over the country. That's really a burden that is old fashioned, outdated minded, the idea that you're going to locate probate practitioners all over the country. So our probate model has solved that problem. And if you have worked with the Probate Pro, and I know many of the people that are listening have, you'll understand that we're that one-stop solution to be able to solve this probate-related issue for deceased estates, brain injured, as well as minors, as well as supplemental needs trusts, and all the related things that go with this probate-related payment complication issue. Reach out to us. We'd love to explore and continue the conversation about a one-stop probate-related solution for your mass tort files.
Okay, makes sense. David, same question to you.
Somewhat a similar answer. So the federal bankruptcy code is a federal law, but there's very localized practices. And so the benefit that we have and what we do is, as a bankruptcy attorney myself, I meet monthly and yearly in person with bankruptcy attorneys and trustees around the country. We built relationships so that we understand what local practices are and can make sure that we're doing these things efficiently, processing these claims files through the bankruptcy process efficiently. And we leverage technology. We have on-staff software developers. So not only do we have the technology to make sure these things go smoothly in our monitor, but we have the ability to integrate with systems like Ryan's or whatever a claim administrator would like to have as far as communication. We're very malleable in that regard. I think that's a big benefit to have that two-way communication. That's an ease of access for the plaintiff attorney or the claims administrator. So those two things really, I think, are important. I think they're important from the beginning. I think Hunter touched on, sometimes their clients forget they even may have a claim, and I see that as a bankruptcy attorney practicing as well. My clients, these things pop up. They don't even remember that they had this claim because they lost touch with their attorney, right? So if we actually can have these monitoring systems in place, spot when these bankruptcies are filed from an early stage, I think it prevents any of those kind of catastrophic situations from coming up.
Makes sense. Ryan, coming over to you. I know we're doing pretty well with time, so give me 30 seconds.
I know liens aren't sexy. I know everyone understands that they have to get resolved. So I'm going to switch it up a little bit. David made a point about us liking to be able to connect to each other. Let us know who's involved. We want to connect to your system. We want to connect to each other's systems. That will give us more data, more ability to analyze, and more ability to move more nimbly so that we can understand the case from every perspective, ultimately making everything faster and hopefully resolving the liens much sooner than you ever would expect.
Excellent. Speaking of data exchange, Damon, give us some final thoughts and what you'd like people to know.
Sure. Whether you're in the beginning stage and you're still staring at your computer screen and trying to organize your files, or you've already done all the work and you're down to the last 5% trying to get them to qualify, we can help you. We have unique access. We're going to make your lives easier. Your staff will start sleeping again, but most importantly, we're going to help the firm and help the claimants. And there's, it needs to be done. It needs to get to Ryan and Hunter and David's hands and Darren's hands. So we're here to help you get through that and make it much more cost effective. And at the end of the day, just a clean process and, take the weight off, the burden off your shoulders.
Awesome. Okay. I don't know if Hunter or Ed, you have any thoughts? We've got about 40 seconds. So if you have anything, otherwise I'll close this out and open it up for questions from the audience.
I would make one more suggestion, and that is to plaintiff lawyers to try to grab the brass ring of an MDL by being the lawyer that the judge goes to. And to do that, you've got to be an honest broker with the judge and never exaggerate. Only a handful of lawyers succeeded that. A couple come to mind, David Boyce and also Dan Layton of Kirkland for defendants. But if you can fill that niche, you will help your clients tremendously.
Awesome. Okay, 30 seconds. Hunter, you're probably going to get the first question from the audience if all that all works out.
I think what Ed said is so important that I'll just echo what he said.
Okay, I love it.
Don't over exaggerate it and tell the truth.
Yes, amen. All right, so everyone, thanks for watching this panel, joining us on the panel. We're now going to open it up for questions from the audience. So we welcome any questions, and we're here to answer those.